flipping it around, we've had more than one case where we've had a client who, in a misguided fashion, decided that, hey, I'm going to download this picture and put it up on the website. And then all of a sudden, a couple of years later, they're getting a letter from the copyright holder seeking to properly enforce their rights. And
right.
they're exposed to damages and attorney's fees, like we said before, in terms of enforcement.
Yeah. Well, that's the statutory damages attorney's fees piece, right? If, the photographers have been savvy and have their registrations in hand, they've got pretty significant leverage. And so, look, I am certainly pro-artist. But obviously, there are times when there's a bit of overreaching, and so you just try to negotiate the best you can, because it is in fact copyright infringement. Hopefully you can negotiate for compensation that's fair to both the photographer and, the innocent person who has unwittingly uploaded an image that they shouldn't have.
You say overreaching, I think about intellectual property, and it seems like that's an arena that there's always kind of interesting cases in your space, and they go both directions. And being a fan of music and somebody who plays guitar, I'm constantly fascinated by how Led Zeppelin got away with basically ripping off everyone that's an old blues act and not paying out any royalties to the folks whose music they were copying. And then ultimately, decades later, they've ended up sharing a lot of those royalties. So if we go back to the trademark question on enforcement, though, if you've gone through this whole effort, it sounds like what you're saying is if you're going through the effort, you really need to be prepared to enforce the marks, because otherwise that effort may end up being completely for naught, because if you let other people nibble away at your trademark interests, then they won't necessarily have value at the end.
Right. And it is something that can happen over time. And so there isn't a requirement that you go after every instance of an infringement right away. I mean, there is a reasonableness metric to the enforcement. So you can pick and choose and be thoughtful and strategic, to use that word again, about your cease and desist program, but one should have one in place. And, we kind of walked through what I've done in the past for, portfolio strategies. I've done the same thing with enforcement. Similarly, you want to take a look at the type of infringer, who they are, what they're doing, and determine what type of letter to write to that person. Because you can write a soft letter, you can write a strong letter. I mean, we've all seen, to your point about overreaching, right? They're called bullies, being a trademark bully. And you would find your cease and desist letter up on the internet, for everyone to mock and be outraged at, how you could go after this poor little person for your trademark. So, there are infringers and there are infringers. And so you have to think strategically and also be mindful of public relations in determining how you handle that particular infringer. So again, you want to categorize what's happening, decide who to enforce against, how to enforce against them, the tone, all of those things are important to consider. Now, I'm not on either side. I'm an intellectual property attorney, and I firmly believe in our system of protection, and I'm pro-artist, but it can happen. And sometimes that, ends up in a public relations nightmare. But to the copyright issue, I mean, that all goes back to why it's important for your registration, because if you've got the leverage of statutory damages and attorney's fees, it's pretty significant leverage.